Few announcements. As always, I request everyone to keep their phones on silent mode. And all those sitting at the back of the hall may kindly come forward. Thank you. I request Advocate Badar Lonare, Executive Member HCBA, to kindly escort Honorable Shri Justice B.R. Gavai onto the dais. I request Advocate Pankaj Navlani, Executive Member HCBA, to kindly escort Honorable Shri Justice Rohinton Nariman onto the dais. Honorable Shri Justice Rohinton Nariman, Judge, Supreme Court of India. Honorable Shri Justice B.R. Gavai, Judge, Bombay High Court. Honorable Judges of the Bombay High Court. Honorable former judges. Advocate M.N. Belekar. Respected senior advocates. Learned members of the judiciary. Members of the Belekar family. Esteemed invitees. Members of the legal fraternity. Students, ladies and gentlemen. The heights by great men reached and kept were not attained by sudden flight, but they, while their companions slept, were toiling upward in the night. With these words of H.W. Longfellow, I welcome you all on behalf of the High Court Bar Association, Nagpur, to the 11th Late Shri N.L. Belekar Memorial Lecture Series 2016. Today we have all gathered here in the memory of one great man, Shri N.L. Belekar, to listen about the lives of many great men who have sculpted the facade of the Nagpur judicial fraternity. And we are indeed privileged that we shall be learning about these eminent personalities from yet another great persona, Honorable Shri Justice Rohinton Nariman, who has kindly consented to be the chief guest for this occasion. My Lord Justice B.R. Gavai has kindly consented to preside over today's function. Advocate N.L. Belekar, in whose memory the HCBA organizes this lecture series, was an eminent lawyer, an erudite jurist, a devoted social worker, and an ardent historian. But above all, he was a humble man with strong moral values and convictions. It is in the memory of this distinguished personality that we organize this lecture series. The topic for today's lecture is Great Judges from Nagpur, with special emphasis on Justice Vivian Bose and Justice M. Hidayatullah. At the outset, I request Ms. Avantika Padhe to recite the invocation song. She will be accompanied by Shri Ajit Padhe on the harmonium, Advocate B.G. Kulkarni on the tabla, and Advocate S.Y. Dev Pujari on the violin.
Ah वसनशालिनी सुकवि सुकृति यशोधवल वसनशालिनी ऋषिमुनिगण पुण्यवचन रत्नमालिनी नवरसमय भुवन शिल्पकल्पिनी वन्दे त्वां सरस्वती ज्ञानरूपिणी वन्दे त्वां सरस्वती ज्ञानरूपिणी प्रज्ञाया ऋतं भरा विश्वतोमुखी प्रतिभाया नवनवीन कल्पनोन्मुखी वाग्देवी यान्तस्थापि च बहिर्मुखी ध्याये त्वां परशक्तिं चित्स्वरूपिणी वन्दे त्वां सरस्वतीं ज्ञानरूपिणी वन्दे त्वां सरस्वतीं ज्ञानरूपिणी रसिक हृदय वीणा रसिक हृदय वीणा झङ्कारकारिणी वन्दे त्वां सरस्वतीं
After this serene rendition, I request the honorable guests on the dais to kindly light the traditional lamp and inaugurate today's function. Thank you. I now request Shri Arun Patil, President HCBA, to kindly welcome Honorable Shri Justice Rohinton Nariman with a bouquet. I request Shri Ajay Mogaukar, Vice President HCBA, to kindly welcome Honorable Shri Justice B.R. Gavai with flowers. I request Shri Anil Thakre, Vice President HCBA, to kindly greet Shri M.N. Belekar, the son of late Advocate N.L. Belekar, with a bouquet. I now request Shri Arun Patil to kindly deliver his welcome address.
Honorable Shri Justice Rohinton F. Nariman, Judge Supreme Court of India, today's distinguished orator. Honorable Shri Justice Bhushan R. Gavai, Administrative Judge, Bombay High Court, Nagpur Bench. Shri M.L. Belekar, generous donor to hold this lecture series. Shri Sadanand Bhutala, Secretary of the High Court Bar Association. Honorable sitting judges of the Bombay High Court, Nagpur Bench. Former Honorable Judges of the Nagpur Bench, Shri Rohit Dev, ASGI and Acting Advocate General of Maharashtra, Senior Counsels, Senior Members of the Bar, Principals of the various colleges, distinguished guests, press and media, my friends and budding lawyers sitting behind. It gives me an immense pleasure to welcome you all in this lecture series, which is started and conducted in the memory of late Shri M.N. Belekar, N.L. Belekar. The High Court Bar Association Nagpur has instituted this lecture series. One of the most illustrious former member of this bar, it was started in 1997. One of the most prestigious and much awaited lecture series in this region. Earlier, 10 lectures have been delivered by distinguished personalities. Late Shri N.L. Belekar, advocate, an eminent lawyer, a perfect jurist, a social worker, a politician, and above all, a very good, down-to-earth human being. Born in a family of weavers in 1905 in village Ashti, district Wardha, rose to a great height because of his sheer hard work, integrity, dedication to this profession. Secured master's degree in arts in 1928. His research paper on importance of Bhoslas in Indian history, read in the annual session of Indian History Congress at Nagpur, held in 1928. Completed his law in 1931 and joined the bar at Nagpur. Immediately elected as Deputy Chairman of Nagpur Local Board in 1931, found Weavers Welfare Board, became President of the CPN Bar Weavers Cooperative Society Nagpur, appointed as a member of All India Handloom Board, founder of Rotary Club at Nagpur in 1964. He contested election of parliamentary seat from Nagpur 1967 as the then Janasangha candidate. There are many landmark reported judgments in the matters argued by him. One of them is reported in AIR 1957, Nagpur, holding that Halba Koshti in central provinces are originally from eastern origin and not from the western region. Second judgment reported in 1965 Supreme Court, holding that a member of scheduled caste who converted to Buddhism is ineligible to contest the election reserved for SC seat in assembly elections. After practicing for 5 decades, he died on 29/1/1979. Indeed, a very great man. The prominent speakers in this lecture series, in last 11 lectures, I quote only few. First subject was discussed by Honorable Sri Justice J.S. Verma, the then Chief Justice of India. Subject was role of the judiciary in the present scenario. The second was Honorable Justice M.N. Venkatachalaya, the Chairman of the Human Right Commission of India. Subject was challenges to the judicial system. Then there was a fifth lecture delivered by Harish Salve, the then Solicitor General of India. Subject was judicial review versus judicial activism. Shri Somnath Chatterjee was the fourth speaker, the then Lok Sabha Speaker. Subject was the role of legislature and the judiciary in protecting and enhancing people's right in our democracy. The last lecture was delivered 2 years back. The speaker was Honorable Justice Ajit Shah, retired judge of the Bombay High Court, Chairman of Law Commission of India. Subject was appointment to the High Court and Supreme Court, issues and controversies. Friends, today we have the speaker, an eminent jurist, one of the best orators in India. The topic is great judges from Nagpur. This bar has great traditions and great history of almost 10 decades. This is an opportunity to listen about our all-time greats from the distinguished guest. I welcome you all again. Thank you.
Thank you, sir. The president of today's function, Honorable Shri Justice B.R. Gavai, has always been a pillar of strength and support in all our endeavors. In every step of our way, His Lordship, in his role as the senior judge of the Nagpur bench, has provided the HCBA with an impetus to fulfill our dreams and give shape to our ideas. My Lord has always encouraged lawyers, young and old alike, to strive to achieve higher and better standards in the field. I request Honorable Shri Justice B.R. Gavai to enlighten us with a few words.
My Lord, Honorable Justice Rohinton Nariman, the Judge, Supreme Court of India, and today's guest speaker, the President of the High Court Bar Association, Shri Arun Patil, Secretary Shri Shraddhananda Bhutada, and all the other office bearers, Advocate M.N. Belekar, Shri Jugal Kishore Gilla, the Advocate General of Chhattisgarh, Shri Rohit Dev, the Acting Advocate General, State of Maharashtra, Srimati Bharti Dangre, the learned government pleader. I'm sorry, I breached a protocol. My all eminent colleagues, past and present, the respected senior members of the bar, Srimati Rohinton, who has gracefully accepted to be here, Srimati Ranjana Vaini, and all the members of the bar, dear friends. I won't stand before you for more than 2 minutes because all of us are eagerly awaiting to listen to Justice Nariman. I take this opportunity to express my gratefulness to Belekar family and the High Court Bar Association for starting this lecture series and cherishing the memory of a great person like N.L. Belekar. Shri N.L. Belekar, apart from being a very successful lawyer, was a great social worker. Dr. Ambedkar has drawn a distinction between a great person and eminent person. He has said that an eminent person is a person who serves the society, and in that way, Shri N.L. Belekar was really an eminent person. It is indeed a great sacrifice on behalf of his family that they have donated a substantial amount to form a corpus to start this lecture series. And also the credit must go to the High Court Bar Association, which has continued this and held so many lectures of eminent persons. As a matter of fact, the topic today chosen by my Lord Justice Nariman is a very interesting topic. We will be knowing about our great judges from him, and therefore, as all of you are eagerly awaiting to listen about our judges from in his words and his inimitable style, I am also eagerly looking forward for the same. As Justice Bobde told us, and as all of us know, that he is one of the most sought after speakers in the country. We have all had an occasion to listen to his speeches and watch them on YouTube. His expertise in constitutional matters is unparalleled. His speaking to the audience is inimitable. With these words, I welcome my Lord Justice Nariman on behalf of my colleagues and the members of the bar and give the rise to him. Thank you.
Thank you, my lord. Our chief guest for the occasion is Honorable Shri Justice Rohinton Nariman. After graduating from Faculty of Law, University of Delhi, my lord completed his master's from Harvard Law School. His lordship then joined the bar in 1979 and was considered an expert on comparative constitutional law and civil law, having over 500 reported Supreme Court judgments to his credit. During his career as a lawyer, my lord has handled several high-profile cases, including the Sakharam Binder case, the Enercon case on the seat of arbitration, the PA Inamdar case on reservation policy of minority educational institutions, the dispute of Reliance Industries, the Khode Distilleries case, which is a milestone in trademark law, among very many others. Intriguingly enough, my lord is also an ordained priest from the Bandra Agyari and has given several lectures on and religious talks all over the world. While it is well known that his lordship was directly elevated from the bar to be the judge of the Supreme Court of India, another remarkable anecdote is that Shri Nariman was only 37 when he was designated as senior counsel. The then Chief Justice of India, Shri Venkatachalya, amended the rules as the minimum age to be a senior counsel was at that time 45. My lord was appointed as the Solicitor General of India on 23rd July 2011 and then elevated to the bench on 7th July 2014. His lordship's varied interests also include a profound knowledge of history, philosophy, literature, science, and fascinatingly, Western classical music. We are indeed honored to have such an eminent jurist and scholar amongst us today to deliver the lecture. I now request Honorable Shri Justice Rohinton Nariman to deliver the 11th Late Shri N.L. Belekar Memorial Lecture for 2016.
Brothers and sisters of this august High Court, the learned President, Vice President, Secretary of the Bar Association, Mr. Belekar, ladies and gentlemen. With Mr. Belekar's permission, if I may, I wish to dedicate this lecture to the memory of two people very dear to me. One is the late Shri Vinod Bobde, who was my closest friend at the bar. And the other is the late Justice A.P. Sen, whose brother has graced today's occasion. Justice A.P. Sen was like a father to Vinod and me. He was very kind to both of us. And before I go to today's subject, I only wish to recall a few anecdotes concerning both of them. The late Justice A.P. Sen called me about a month before he retired and in his usual way was most enigmatic on the telephone. He said to me, Rohinton, all roads lead to Rome. So I said, sir, it's difficult for me to fathom what exactly you mean. He repeated himself. Again I said, I'm sorry, I don't understand. So in that inimitable chuckle of his, he told me over the phone, Arey bhai, Western classical music, there is only one place I can go to, and that is you. So I then started dubbing, because he used to use the expression dubbing for him, all sorts of delicacies which he was used to, and some new things as well. And that went on till he died. But I must tell you that he was so independent that he refused to accept any cassette from me, ever. If ever I did something on a cassette, he would always replace it with a new cassette. Another thing that comes to mind is that he painted the most lurid picture of ever becoming a judge. He told me that was the greatest mistake of his life. He said earlier, He was free to do exactly what he wanted. But now he was put in a cage. And having been put in this cage, he was not at all free. He was tied, with everybody, the entire world, staring at him. I must say, at that point of time, I didn't realize what exactly he meant. But today I get some idea of what he meant. The other interesting anecdote concerns both Vinod and him. Very early in my career, I went to the Supreme Court in early 1986. By then, Vinod was an established senior advocate doing extremely well. And Vinod was arguing some landlord-tenant dispute before Justice A.P. Sen with his brother judge. And Justice A.P. Sen saw me sitting behind and called me to the front and said, "We are appointing you amicus curiae to do only one thing, to tell us that the consent terms handed up by the two, landlord and tenant, will not bind this court under Article 136. And the consent terms were somewhat reasonable. They were that the tenant, who was in some ancient bungalow in Allahabad, would himself build an outhouse in the same premises at his own cost and would continue as tenant in that outhouse, so that the main bungalow could then be used by all the siblings of the person who died, all of whom were away from Allahabad and all of whom would come for vacations." Now, given this task, another call came from the learned judge on Saturday morning, asking me if I had read the brief carefully. So I said, "Yes, sir, I've read the brief." So he said, "Please turn to page 80. The expression political bigwig is used at that page, which only means that the appellant is trying to twist the arm of the respondent and trying to do something which he should not get away with. So therefore, please come properly armed with all the authorities." I went properly armed with all the authorities on a Tuesday morning. Justice Sen made the mistake of asking me, a young man, as to what I felt about the consent terms. I said I thought they were eminently fair and reasonable. So he immediately, startled, regained his composure and dictated an order in which he thanked me as amicus curiae and recorded the consent terms, but made it clear that it was I who thought they were fair, not him. With these few prefatory remarks, we now get down to the two great judges who adorned this High Court and who then adorned our institution, the Supreme Court of India. Justice Vivian Bose was a man of many parts. As most of you probably know, these parts extended to photography and magic, apart from many other things. And he was born in a very, very distinguished family, his grandfather being a lawyer. He was, of course, born to an English mother, and he married an American lady, whose father, in turn, was a gentleman called John Mott, who won the Nobel Peace Prize in 1946. Among the many things that this great man did were to travel alone all the way to London and travel all the way back from London in two separate trips. One made in 1932 and the other made in 1956, when he demitted office as a Supreme Court judge, only to be asked to join again as an ad hoc judge for one more year. This great man was great and shone in a constellation of stars, because I must first give you the background of the court which he first came to. Our Supreme Court, when it was declared in 1950, was to consist of 8 honorable judges. 6 judges were appointed in the first shot. Those 6 were 6 persons who had already served on the federal court, which preceded our court. The 6th being Justice S.R. Das, who had just served for a few days, before which he was elevated to our court. Now, each one of these persons was, as I told you, a star in himself. The first Chief Justice Kanya unfortunately died early. Otherwise, he'd have continued for another 5 years as Chief Justice. And a number of persons would not have become Chief Justice as a result. Only Justice Das would have succeeded. After Justice Kanya came Justice Fazal Ali, who, though he served on the court for only 2 years, came out with some masterful dissenting judgments. His dissent in Gopalan is one of the classics, which all of you must read. And it was so far-sighted that it presaged at least 2 or 3 other judgments, which undid Gopalan later, one being Maneka Gandhi, another being R.C. Cooper. Apart from this judgment, he also dissented in the early 2 19-1A cases, Romesh Thapar and Brij Bhushan, and was proved right again, because it is his dissent that was taken up by the Constituent Assembly, which was then Parliament at that point of time. Which Constituent Assembly passed our First Amendment and added the word public order, which was what Justice Fazal Ali had said should have been already there, and not being already there, read it in. Apart from Justice Fazal Ali, then came the great Patanjali Shastri, who was another very great man who became Chief Justice, who is known for many of his great judgments, the most prominent of which are State of Madras versus V.G. Rao, as to what exactly constitutes reasonable restrictions in the public interest under Article 19(1)G. And after Justice Patanjali, there came the greatest of all of them, Justice B.K. Mukherjee, who was a titan. He was born on 15th August. And 15th August is not only the birthday of our great nation, but also the birthday of the Emperor Napoleon. He was indeed the Napoleon of the law in those days. And he was so outstanding that in a short period of 5.5 years, he died while on the bench. He had so established himself that Justice William Douglas actually came to India on the heels of his death to deliver a Tagore law lecture which was entitled From Marshall, which was the greatest Chief Justice of the United States Supreme Court, to Mukherjee. This is how great this man was. Then, as I told you, Justice Sudhiranjan Das, the sixth judge who became our Chief Justice for about 3.5 years, again known for a number of sterling judgments, including the famous one on Article 30, which was a presidential reference, Re Kerala Education Bill. And apart from these 6, 2 were later added, Justice Chandrasekhar Iyer and Vivian Bose as number 8, which then completed the quorum of the Supreme Court. Justice Vivian Bose spoke through his judgments almost immediately. The first major judgment that came from his pen was the famous judgment in Re Delhi Laws Act. All of you must have read it as students of law. Interestingly enough, it was delivered by a bench of 7 judges, each judge speaking for himself. It is perhaps the only judgment that I know of in our court, where in a bench of 7, every single judge has spoken for himself. And of course, that caused anarchy, precedential anarchy, if I may put it that way, because it had to be explained by none other than Justice Bose in a judgment 5 years later in Rajnarayan Singh's case, where Justice Bose lays down as a rule of precedent the fact that if 2 out of 7 judges are the least, as he put it, common denominator among all of them, the others all going upwards, but then all of the 7 agree to at least this proposition, then those 2 become the ratio decidendi of the judgment, which was a unique proposition in its day. And of course, his own judgment and Justice B.K. Mukherjee's judgment as a result became the ratio decidendi of the Delhi Laws Act. Very early in his first strike, so to speak, he spoke of our constitutional values, and this is something that he spoke of throughout his short tenure of 6 years. The first thing he said is that we have given to ourselves the free way of life. He put it very simply, very beautifully. The democratic way is the free way of life. And he said, Parliament as an institution is an institution which has been trusted by the Constitution to make laws. Therefore, it must make those laws itself and delegate as little as possible, which was the point that arose in the Delhi Law's judgment. Immediately thereafter came a few preventive detention cases, the most famous of which was Gopalan's case, which, as you know, was undone years and years later. But Justice Bose spoke again in a dissenting voice in two of the early ones. In Ram Singh, again he gave us his constitutional vision in a preventive detention case, where on facts, when a ground had to be given to a detainee for a detention order, the ground, according to Justice Bose, had to be so specific, because it was a charge after all, that it should in fact give extracts of the speech which was supposed to have been the cause for the person being put or being preventively detained. And if it did not do so, the ground itself was bad and the person should have been set free. As I said, he was in a dissent. But what was interesting was his constitutional vision in the dissent. He said, what is important is the right and not the limitation on the right. We must remember, we are speaking of fundamental rights. So what is fundamental in his language is the right, not the limitation on it. And second, and more importantly, that the moment there is any doubt, it must be resolved in favor of the subject, that is the citizen, that is the people of India. Now, having spoken this early and this emphatically, it was followed up in another judgment on the heels of this judgment in S. Krishnan's case, again in dissent. S. Krishnan involved a very interesting question as to whether Section 11 of the Preventive Detention Act of 1950 was constitutionally valid. The argument ran thus: Article 22 into bracket 7 specifically gives Parliament the power to enact a law which would lay down the maximum period for which a person can be detained. That is, after an advisory board has looked at him and said that yes, this detention order is valid. Now, what Parliament did in Section 11 was to say that this can continue until the executive authority thinks fit. And the then Attorney General tried to support this by saying that in any case, this was a temporary act. This act would expire within a few months. And therefore, what was really meant was a few months. That was bought by the majority, but not by Justice Bose. Justice Bose emphatically dissented and again stated his constitutional vision in words which ring in our ears today. He said this constitution is not a malleable mass of clay which is inert and lifeless, but it is a document which is full of life, full of vigor. And the life and the vigor are in order that we, the citizens of India, may live freely, what he continuously stressed as the free way of life in democratic society. This again was a landmark judgment. And what is interesting about this judgment is his reference to the Bastille. Now you will find both Justice Bose and Justice Hidayatullah were extremely well read. And their judgments are peppered with a number of historical references, literary references, and the like. Now the first glimpse we get to see of Justice Bose's reading is the Bastille. The Bastille, as all of you know, was the symbol of arbitrary and despotic authority, in that the Bastille was a prison in Paris. And persons just rotted there sometimes in solitary confinement until they died. All of you know the beginning of A Tale of Two Cities by Charles Dickens, which epitomizes what exactly the French Revolution was about and why it came about. Speaking of Dr. Alexandre Manet, a person who spent his entire life in the Bastille and then, poor chap, had gone off his head. The famous words are, it was the best of times, it was the worst of times, it was the age of wisdom, it was the age of foolishness, it was the epoch of belief, it was the epoch of incredulity, it was the season of light, it was the season of darkness, it was the spring of hope, it was the winter of despair. We were all going direct to heaven, we were all going direct the other way. In short, the present was so like the present period that even its noisiest authorities insisted on its being remarked upon in terms which are of the superlative degree only. And then, of course, the next paragraph goes on to talk of a king with a large jaw and a queen with a plain face on the throne of England, and a king with a large jaw and a queen with a pretty face on the throne of France. The king and queen being King George III and his wife, and Louis XVI and his Austrian wife, Marie Antoinette. King George III, poor fellow, was off his head for bouts, because he had apparently bouts of porphyria, which was a disease which could not be cured in those days. So he was referred to as Mad King George. He had a very long reign, and it is in his reign that the American colonies gained their independence. Of course, Louis XVI and Marie Antoinette both faced the guillotine, and their heads were cut off within 4 years of the Bastille being stormed. And this, of course, then brings us to the period of Napoleon, because the very next judgment that Justice Bose speaks about in Harla versus state of Rajasthan is the Code Napoleon. Now, Harla's case was a judgment in which the court had to decide whether a Jaipur Opium Act, which was a statute which was of a princely ruler, never published, it was only in the drawer, had the force of law. Justice Bose emphatically said, no, it did not have the force of law, because a law is something which cannot come into force until and unless it is promulgated, it is published. And for this, he referred to and relied upon the Code Napoleon. The very first article of the Code Napoleon says that every law that is made in any of these codes shall be published in a manner that it can be known effectively and well to the people. Now, Napoleon, when the Emperor Napoleon, when he was at St. Helena and dying, was asked about his great achievements and about the great victories that he had in battle. And his answer was, yes, I did have victories in battle, 42 of them, but they were all wiped out by Waterloo. What will never be wiped out is my code. And his code, let me tell you, he was a genius. Even though he was not a lawyer, he had, as first consul, before he became emperor, set up a committee of lawyers, one of whom was Cambaceres, who was a consul with him. And on the other side, strict constructionists. So he wanted them to gather the laws together and put them before an assembly, which he presided over. Each article was debated in that assembly, and the emperor was present at most of the sessions. And ultimately, it was what the emperor dictated that became law. So the Code Napoleon is really the Code Napoleon. And Justice Bose, in referring to it, did homage to one of the great lawgivers. Incidentally, Napoleon, along with Justinian and so many others, are all up on a ceiling in friezes in the US Supreme Court. There was, of course, some debate about whether Prophet Muhammad should be there and shown. And Chief Justice Rehnquist said, no, let him be, doesn't matter, we'll face the consequence. And he continues to be there. But coming back to Justice Vivian Bose and his great judgments, we move on now to two judgments, both of which came from West Bengal. They were these special court enactments of West Bengal, because the idea was that they wanted to swiftly bring to book certain offenders in certain serious offenses. The first, Section 5 of the first act, was so widely worded that everybody struck it down. But the rest of the provisions were upheld. Justice Bose dissented. And this time, when he dissented, again, he gave us his constitutional vision. And his constitution vision was that the idea of this constitution is not for judges, is not that it's for lawyers, it is for the common man in his inimitable language, used in a tax assessment case. There could be nothing more lifeless than a tax assessment case, and that to a transfer of a tax assessment. In BD supply, he said it is for the butcher, the baker, and the candlestick maker. Beautifully put. And this great constitutional vision shines out of these two cases as well. One other interesting reference he makes, and this is the third reference now to a historical fact, in Bajoria's case, which is the second West Bengal case, is the Star Chamber. And he put it beautifully. He said Ramchandar and Sakaram, he took two names, are both tried with very serious offenses. One of them is tried by the ordinary law. The other is tried by this special law in which some procedural safeguards, unfortunately, are not available because the trial has to be swift. He said that cannot pass muster under the equality clause. And he also went into equality in great detail. What is equality? Ultimately, he said, it is what you feel is equal. It's very easy for a lawyer to tell you something is equal or something is unequal, because you get out of something equal by the doctrine of classification. And the doctrine of classification, again, has its own limitations. So ultimately, it is what you feel. It is what a trained judicial mind feels about the subject. And if he feels there has been injustice done, he must strike it wherever he sees it. So he spoke about Ramchandra being tried, unlike Sakaram, by a procedure which was so invidious that it could be likened to the Star Chamber. Now, what is a Star Chamber? Interestingly enough, everybody who has heard of a Star Chamber thinks that it's something like a dungeon. It's something so horrible that anything that emanates from a Star Chamber is secret, dark, terrible penalties, etc. The exact opposite is the truth, at least when the Star Chamber was first set up. It was set up under the reign of Henry VII. Now, Henry VII was a new monarch in England. He founded a new dynasty, the dynasty of Henry VIII and Elizabeth, the Tudor dynasty. And in 1485, he had just succeeded against the last Plantagenet king, who had ruled for some 300 odd years. In setting up this new dynasty, the first thing that he had to do was to bring to book all the errant barons, for which the Star Chamber was set up. So the idea of the Star Chamber really was the opposite. The idea was that whereas the king's bench, the chancellor, etc., didn't reach out and strike rich persons and powerful persons, the Star Chamber was set up to do exactly this. And it worked well. It worked so well that in fact it was commented upon by very, very early British commentators as being the ideal court of justice, the only court which is imbued with morality, not just law. However, from the time of Henry VIII, Elizabeth, James I onwards, you saw a steady decline until in the time of Charles I, who had to pay with his head. It became this horrible instrument of oppression and torture. And it is in that sense that Justice Bose used the expression Star Chamber. One of the resort even beyond a review being dismissed, something called a curative petition. Now, the curative petition goes to 5 senior judges of the Supreme Court and must be signed by at least 2 senior advocates before it can so go. They must satisfy themselves that the grounds mentioned in Rupa Hura have been made out. This is exactly something taken from the Star Chamber, because the Star Chamber in those days required the lawyer to certify that the case was fit enough for the Star Chamber to try it. And in an interesting US Supreme Court judgment in Ferretta's case, with a stinging dissent given by Chief Justice Berger, speaking for three, Justice Potter Stewart went into the history of the Star Chamber and ultimately struck down a state statute which insisted that a lawyer be given to a person to conduct his defense, even though he didn't want the lawyer. The Chief Justice in dissent put it very, very well when he said that today's judgment, that is the majority judgment, allows a citizen to be made a fool of himself. Why a fool of himself? Because obviously a person conducting his own defense will not know the subtle nuances of criminal law to defend himself adequately. So we go back to Justice Bose's concept of the Star Chamber in Kedarnath Bajoria as being an instrument of oppression. Incidentally, this Star Chamber was done away with as early as 1641. That is 8 years before Charles I lost his head. And we now move on to another very interesting judgment that he wrote, Surendra Singh, in 1954. Here there was a Privy Council judgment which specifically said that even though a judge may not have signed his judgment, ultimately, if the judge has given a full copy of the judgment and has not signed the judgment, has not delivered it, these are all matters of procedure and should be done away with. The judgment is complete by itself. Justice Bose distinguished the Privy Council judgment, saying that was a civil case. This is a case of death. Number one. Number two, the reason why this is not procedural is that a judgment becomes final only on pronouncement, not even on signature. And why does it become final only on pronouncement? Because till the time it is pronounced, the judge can say, something has intervened by which I want to either change the judgment or scrap it. So, he was faced on the facts in that case with a death sentence issued and which had to be confirmed by the High Court. High Court consisted of a division bench. One of the learned judges signed the judgment, delivered it, and died. The other learned judge pronounced it in open court, and the question was whether this judgment met with the requirement of a judgment as known in law. Justice Bose said it didn't. He said, despite the Privy Council judgment, despite the fact that the man was dead and could not therefore change his mind, ultimately it is only the solemnity of a court in which a pronouncement is made. And it is that point, it's very important to fix the point at which a judgment is ultimately said to have been made. That point has never been reached in this case. Therefore, we set aside the High Court judgment and send it back. One other very interesting judgment in the 55s, J.K. Steele, is a judgment which deals with a very interesting concept, benevolent despotism. Now, many people, many citizens, when they speak about our constitution, about our way of government, about our laws, etc., often say, either danda chahiye. It's very important to have a dictator who's benevolent. Justice Bose strongly disagreed and said, benevolent despotism is anathema to our constitution. There can be no part of this constitution which endorses anything like despotism, benevolent or otherwise. And the moment the word despotism comes in, the rule of law goes out. So this is a very interesting and important judgment to give to persons who feel that the democratic way of life, even though it is a good way, is a way which is so fraught with delays and so many other problems that it would be so much better if one were to have somebody who would be like Napoleon, but would be a benevolent Napoleon. Answer, beautifully put, is no. Another great judgment that comes to mind is a unique judgment in state of UP versus Muhammad Nu, a 1958 judgment. Again, he was in dissent. And the question was whether Article 226 would apply to to an executive order that was made before the Constitution. The majority went into the technical doctrine of merger, said that as the appeal was dismissed and a further appeal was just dismissed with one word, there was in fact no merger. The original judgment stood, and therefore 226 had no retroactive operation. Justice Bose dissented. Justice Bose specifically said that first and foremost, he likened the manner in which he conducted that departmental inquiry to a Gilbert and Sullivan opera. Now, Gilbert and Sullivan in Western classical music were a great team. Gilbert was the lyricist, Sir Arthur Sullivan was the person who wrote the actual music. And they were comic operas which parodied the England of the 18th century. So he said, look at the parody of justice that is done here. The Deputy Superintendent of Police solemnly first sits as a judge. Then he finds that there's not enough evidence on one particular point, so he comes off the rostrum, gives evidence himself, comes back onto the rostrum, and then finally dictates judgment. He said, this is not how departmental trials should be conducted. And I'm sorry to say that Article 226 may or may not be retrospective. That's hardly the point. The point is, has this man conducted the trial fairly? And if he hasn't, our arms are long enough to strike down such orders. As I told you, in 1956, the great judge retired at the age of 65. He undertook the return London trip on his own. And after 1 year, Chief Justice Sudhir Ranjan Das asked him to come back as an ad hoc judge, which he did for 1 year. And almost the last judgment that he ever delivered is again peppered with very, very interesting little anecdotes. The last judgment is a judgment reported in 1958, which the cause title of which reads, Tisco versus the Union of India. Now, the question which arose in that case was whether a particular state law, when it wanted to grab one aspect of a sale transaction to tax it, had extraterritorial effect in order to do so successfully. Again, Justice Bose dissented. Majority said, yes, it did. The first thing that he said was that you cannot have something like, and he likened it to a body with so many parts. And you can't say that, look, a quivering liver can be got hold of by Maharashtra, heart can be got hold of by Gujarat, some other entrail can be got hold of by Andhra Pradesh, and each of them can tax this as a sale. He said, no, that's not the constitutional conception. And ultimately, he likened these states to a group of hungry hawks swooping down upon this sale transaction. And then used the great Churchillian expression, some hawks, some sale. Now you remember Winston Churchill made a great speech on the 30th of December 1941 in Ottawa as Prime Minister in the middle of the Second World War, in which he spoke about Marshal Pétain telling the French president, just after the Battle of France was over, that Germany will wring England's neck like a chicken. And the answer that was given by Churchill himself in a famous speech, in this speech was, some chicken, some neck. Now, this beautiful imagery was brought in virtually just the last of Justice Bose's judgments. Another very interesting bit of imagery was to bring an animal in, a dog. And he said, can you say that state A, because a dog's tail has been cut off and sent to state A, can tax the dog as a dog? The dog went with its master to state B, therefore that state can tax the dog, again as a dog. State C similarly can do something with a dog because it ran away from its master and went into state C. Now, can you trap this animal in each of the three states and say, yes, what I'm doing is only taxing the dog as a dog. So the obvious answer is no. Now, the imagery of a dog has, interestingly enough, been used long before Justice Bose used it. Lord Justice Scruton and Lord Mom, who came down and sat in the King's Bench, in England they do that, in 1934, had to deal with a goodwill case. And in that goodwill case, the question was, what kind of goodwill do you say comes within the meaning of the terms of the Act? Is it a goodwill that goes with the master, with the place, otherwise? So the dog was brought in. A dog is somebody who goes only with his master. So the kind of goodwill that you would have is mentioned as dog goodwill if the place is shut down and the dog goes with the master. Otherwise, it is called cat goodwill, in which case it is the place that is important and not the master. The goodwill is only attached to the place. The third animal used was a rat, saying that rats, in fact, have no goodwill at all because they in fact run away from places like this. And Lord Mom brought in a fourth animal, a rabbit, and said a rabbit would have goodwill in cases where, like the Kirana shops around, a customer goes to the Kirana shop because it's a Kirana shop and not otherwise. So interestingly enough, having dealt with with Justice Bose in some detail, has no time to go into so many other great judgments. What is interesting is that all these judgments are peppered with themes from history, literature, scenes from common day, everyday life, all of which ultimately go to make up what in Justice Bose's words were an independent, fearless judiciary, which alone is the bulwark of our constitutional democracy. This is how I think one can best sum up Justice Vivian Bose's work in the Supreme Court. We now come to the second great judge. Now, this judge, again, is a very interesting judge. He straddles 3 decades, first and foremost. He was confirmed as a Supreme Court judge in 1959, and he retired as Chief Justice of India in 1971. He also straddles 3 offices. Not only was he Chief Justice of India, he was acting President of India and Vice President of India. He was also one of the youngest persons ever to become Advocate General, 38 of this great state. He was also a very young judge. And the interesting thing about this judge again is that his judgments, though they are much longer than Bose's and much more detailed, are again peppered with n number of instances from fundamentally English literature and then history. Now, one of the early interesting judgments was a judgment reported in 1963 in the New India Sugar Mills case. Here, Justice Hidayatullah was in dissent. And interestingly enough, the question before the court was whether compulsory sales were sales nonetheless, which could be taxed as such. And Justice Hidayatullah went into Roman law to discover an answer. He said, this is nothing new. This existed at the time of Justinian, one of the other great lawgivers, the man who built Hagia Sophia in Turkey today. And this was exactly the dispute between some labio and some proculus. And ultimately, Justinian decided in favor of proculus. Now, what was that great debate? The debate was about whether, when a third party fixes a price, can it yet be said to be a consensual transaction and be called a sale? So the Roman law answer was yes. Justice Hidayatullah then went on to follow that and said, yes, why couldn't it be in our law as well? And ultimately found that despite the fact that under an Essential Commodities Act control order, not only is the price fixed, but even the parties are in accordance with whom the controller directs to supply to whom, that would amount to a sale.